The structure of my presentation then is a much more legal presentation, and what I particularly want to do is to compare the way market abuse is or can be attacked under REMIT in comparison with European and national competition law. Article 102 of the treaty, now called the Treaty of the Functioning of the European Union, or the Lisbon Treaty, prohibits abuse of a dominant position. So there are some parallels, some overlaps, but there are also significant gaps in competition law, which many lawyers think could be filled by the new provisions and powers that regulators will have under REMIT. There are perhaps also some problems, and I think this was already touched on from the economic perspective, that some people argue that REMIT might, in fact, create too much transparency in the market. And from a legal perspective, this could also give rise to collusion, and we do have examples of this happening, which will have to be tackled under competition law. And the debate about how much transparency should be available in markets has been one that has been very lively and has emerged in the context of the amendments to the current electricity regulations annex, where the Commission has been amending the so-called transparency guidelines. There's a third element to the whole discussion of REMIT from a legal perspective, and that is which regulator does what with which information. There is a lot of potential information going backwards and forwards between regulators now that REMIT is in place, and that is of some concern. Now, I don't know if I'll get there in the presentation, maybe I'll have too much to say, but that is dealt with in my presentation, and I can certainly take questions on that. So, what is abuse of a dominant position from a legal perspective, and how do we compare that to, excuse me, to market manipulation, which is what REMIT is meant to stop? Well, Article 102 of the treaty, the classic antitrust approach, is based on defining relevant markets, trying to find out what the state of competition is on a particular product market in a geographical area. So it's very important, first of all, to define the market you're dealing with. And traditionally, the competition authority will try to narrow down the market as much as possible, because then, obviously, the share of the target of the company that they're suspecting is likely to be bigger. So we see in energy markets, in electricity and gas markets, markets being defined now in relatively narrow terms. So we have separate markets for ancillary services, separate markets for balancing services, and you can even see cases where separate markets are seen for different parts of the day or public holidays as compared to normal working days. These can all be separate markets. Then you have to establish that the target company is actually dominant. Now that is a whole, I could fill a whole day telling you about that concept, but in any event, the rule of thumb is that if you have as a company more than 25% of a market share on a relevant market, you could be seen to be dominant. So it's not necessarily that you have a large market share, even a relatively low one, given that there might be other factors affecting market entry, could give you, in fact, dominance. And then you have to establish, as a regulator, as a competition authority, you have to establish that there has been abuse. It's not an abuse to be dominant, you actually have to abuse your dominant position. And here, the treaty itself provides some guidance, and generally we see the treaty article 102 dividing the types of abuse into the types that harm consumers, such as exploitative pricing, and the type of abuses that harm competitors. You try and get rid of your competitors, you try to drive them out of the market, you foreclose competition. Exclusionary abuses. So when we're looking at market manipulation and wholesale market manipulation being the subject of REMIT, we're obviously more interested in the second category, exclusionary abuses, if we are looking at what we can do under competition law in the same types of situations. But I would note that the Commission has traditionally, in its own antitrust enforcement, been keener on focusing on exclusionary abuses until quite recently. And we see that policy changing a little bit. And now the Commission is looking at problems around excessive pricing, particularly in relation to its investigation into Gazprom. The Commission has always been rather uncomfortable getting into problems of excessive pricing, as this takes it down the route of being a regulator, that it will have to determine what a reasonable or a fair price would have been in order to establish what an excessive price is. So it's a dangerous activity which the Commission generally doesn't like. The great thing about Article 102 from the point of view of competition regulators is that it provides examples of abuse, unfair prices, refusal to supply, tying products together, bundling them when they don't necessarily have to be sold together. But this list is not exhaustive, so you can add to it and expand. And that's always a comfortable thought if you're a regulator, that there's more up your sleeve than you think, or that the treaty powers or the legal powers that you have seem to give you. So, although in theory Article 102 of the treaty and many national legal provisions echo or indeed replicate Article 102 into their national competition law, it's a wide-reaching provision, but it's not proved very easy to enforce in energy markets. And we see competition authorities and regulators often struggling valiantly to deal with certain behavior which they suspect as being abusive, but being then knocked back by their courts because they haven't met requisite standards of proof. One of the classic examples is one that I've outlined here, which was a case in Spain where the Spanish regulator was worried about activity on the intraday market and was convinced that there was some collusion going on between the generators, which meant that this allowed prices to be manipulated and prices pushed up on the balancing market. So the regulators were worried, in fact, that the generators were able to withhold capacity and then force prices up on the balancing market. But the Supreme Court here, when it looked at the way the regulators had dealt with the problem, said, well, wait a minute, in fact, the generators were doing nothing more than taking a bet. And they made a bet with risks. There was no definite guarantee that the risks or the bet would pay off. So you could say this is speculation. It's not necessarily manipulation when we come to look at that, and it was certainly not abuse. And for the Supreme Court, what was particularly problematic was that it was very difficult to pinpoint that there was any dominance here in the relevant market at the relevant time. The coalitions were shifting on a daily basis. So it was very difficult for the Supreme Court to accept that the conventional tests of abuse had actually been met here. It's unlikely there was dominance, and it was unlikely that there had been actually systematic abuse. There was evidence that on 3 days there had been rather strange behavior, but that could have just been speculation. So that case was thrown out. We have another more recent case where EDF was accused of predatory pricing on the French balancing market. Now, predatory pricing is also a classic form of abuse under Article 102, so you offer lower prices with the intention of driving the competition out. Now here, in this case, the French authorities investigated the complaints that EDF had abused its dominant position on the French balancing market by pricing too low. Now, I think I might have to move on a little bit more quickly here rather than go through all the cases. But here, what the regulator looked at again was this a rational strategy for EDF to offer lower prices at certain times on the balancing market? Had it sacrificed part of its profits by offering its capacities at the prices it did in tenders which were organized by RTE, the French TSO? And the regulator looked at, in fact, the way EDF had decided what on its strategy. Was that a fair and rational strategy? So it was confronted with alternatives. It could either dedicate its capacities for the wholesale market to sell when prices were high, or it could dedicate them to selling them for tertiary reserves, for the TSO's tertiary reserves. So the conclusion was that the cost for EDF to participate in these auctions was the opportunity cost of not selling its capacity on the French wholesale market. So it was a rational approach. And EDF here could provide the documents, the information to substantiate that the prices, in fact, were worked out on a fair and rational basis. So that was a good example of a French competition authority looking at a fairly technical problem in the balancing markets in France and working in corroboration with the French regulator to come up with the conclusion that there was no abuse. A more recent example in Italy, where the Italian Competition Authority has looked at Enel's activities on the market in Sicily, where there were some doubts that the fact that price fluctuations in Sicily were to be explained by capacity constraints or any normal problem in running the electricity sector. And it seemed that indeed there was an attempt to push prices up, especially peak prices. And in that case, Enel reached a settlement. That means that there's an informal deal done, in fact, with the competition authority. So you don't actually admit that you've broken the law. You don't actually admit as a company that you've abused your dominant position. And luckily for the competition authority, they don't have to prove it either. But of course, you wouldn't accept the settlement if there wasn't something wrong. And in this case, Enel accepted what we call a behavioral remedy, so that they would accept that price caps would be imposed on their capacity bids in the day-ahead market in the 2-year period, 2011 to 13. And for antitrust, it's become more preferable to accept structural remedies rather than this type of behavioral remedy. A structural remedy is usually one then which leads to plant being sold to certain activities, then being separated off from the dominant player. But in this case, the settlement allowed this behavioral remedy, a price cap, which of course has the disadvantage that somebody has to monitor that that price cap is in fact in place and is properly followed. Now I just want to conclude with a quick look to the US to conclude this section on antitrust, to let you see just how difficult it is to enforce competition law or antitrust law in electricity markets. And the case I just want to touch on is a US case called Keyspan, which involved an investigation by the US Department of Justice into what was called the Keyspan swap. And this swap involved a hedging contract in a very tight market in in the northeast of the USA, where Keyspan basically tried through this financial swap to push out competitors, to push down the capacity so that it could then re-enter the market and offer much higher prices. Now, despite the fact that this seemed to be a fairly blatant manipulation and a fairly blatant abuse, in fact, again, a settlement was reached. There was no penalty imposed on Keyspan because this was an accusation that Keyspan had violated Section 1 of the Sherman Act, which is the abuse of a monopoly, which is a criminal which leads to criminal sanctions in the US. And so the burden of proof is very high. And the Department of Justice was unsure that it could meet that standard. And so they accepted what is called, rather unfortunately, a disgorgement, which meant that they settled the case, but they made Keyspan pay the costs of running the investigation, which were estimated at $12 million, to conclude the case. So $12 million just in administrative costs. So it was an interesting case because here you could see that the market was very tight. There were 3 players. They were all seemed to be pivotal suppliers. They were subject to regulated bids and price caps. And Keyspan thought that these tight market conditions would end due to the entry of new capacity caps, and that's where the hedge came in. And it tried to buy one of the other players out, but it couldn't because it was blocked for merger reasons. So that's why it decided, well, it will acquire a financial interest in its competitor, Astoria, through this Keyspan swap. And that then, in turn, led to an offsetting agreement with a financial institution, a financial counterparty called the Astoria Hedge. So this was an interesting interaction of financial and physical activities on the market. And the idea was that the Keyspan swap would eliminate Keyspan's incentive to compete for sales by lowering prices so it could then still bid up to its cap. And this would cause the capacity markets prices to clear at a higher level than would have been the case absent the agreement. So the swap provided Keyspan with revenues from Astoria's capacity in addition to its own revenues, and it could still bid its cap even though a significant proportion of its own capacity went unsold. So it kept the market prices high. Now, the US authorities believe that absent the swap, Keyspan and pivotal suppliers would have engaged in tier pricing at prices lower than their cap. So it was a very complex interaction then of physical and financial contracts, which seemed to indicate abuse of a dominant position. It seemed to indicate that there was market manipulation. And we just heard how important it is to get information. Even with information here, the regulators had to analyze and chew through 1 million pages of documents. And they did have access to the bidding data, which they had analyzed. But even still, they were not able to conclude this case with any final settlement or penalties. So that, I think, is a lesson as to how difficult it can be for regulators to really get to grips with these very complex cases. Now, when we get to REMIT, how long have I got? 10 minutes, okay. When we get to looking at REMIT, of course, we move into a related concept of abuse, that of market manipulation. And the key thing here is that you are, as a player, trying to change a market outcome by entering into transactions, and I'm taking this from REMIT, and issuing orders to trade, or taking any other action with the intention of manipulating the market. So this is not a particularly helpful definition, because it tells you, well, if you do something with the intention of manipulating the market, then you have a problem. But what about all sorts of cases where you are involved in speculation, which is not necessarily manipulation, but that has a certain outcome? How important is intention? And this is one of the key problems from a legal point of view. How do we establish what intention is? And this is also, with the second category of offences, disseminating information with the intention of giving false signals or misleading signals. Again, it's intention here that's the key to defining the abuse. Now, there has been a lot of criticism of these definitions, imported, of course, from financial markets into the energy market, as being far too vague. And an example that's often quoted, this concept of an abusive squeeze, which is taken from the financial markets and put into recital 14 of REMIT, which is a conduct to secure a decisive position over supply or demand of a wholesale energy product, so that fixing prices or creating other unfair trading conditions. Now, what are unfair trading conditions? Again, it's all very vague. And this is why there has been a great deal of concern as to what is going to happen. And remember, at this stage, as you probably also have heard, it will be really as of June of this year, with the rollout of sanctions and penalties, that these provisions are really going to start to bite. Now, at the same time as recognizing a lot of the fundamental difficulties with some of the definitions in REMIT, there is one thing that certainly antitrust lawyers, energy lawyers, usually have done a lot of antitrust, so that's what we're familiar with. This is for us financial regulation, and it's new, and therefore we're very suspicious of it. But one thing that we think is of great consequence is the fact that it's probably unlikely that the test of dominance will have to be looked into when we apply REMIT to energy markets, to the energy wholesale market. So this is the big difference between REMIT and Article 102, which I was talking about before. In Article 102 cases, you have to prove that the market party is dominant and that it has abused that dominant position. With REMIT, there's no question that dominance has to be established, although you have to show that the impact of the behavior is significant, that the market manipulation or the insider trading that's involved will have significant impact on the market. However, we think that that's certainly something different from dominance. So that will probably take us into new fields. However, and as I'm trying to stress here, the difference between manipulation and speculation is one that is problematic. And there's been a lot of analysis devoted to trying to identify, well, when are hedging practices in energy markets, which are standard practices, when are these going to lead to an outcome that's not just normal practice, but which could be, in fact, manipulation. Now, you probably heard a little bit yesterday about the different practices that can be used when trading, and this is then something that is now a concern with REMIT because of the very vagueness of the definitions. Now, what the agency, the ACER is supposed to do is give guidance on what it considers then to be accepted market practices, AMPs. And therefore, to counterbalance these very vague definitions in REMIT, the agency, in its guidance, has offered market parties then some ideas as to what can be accepted market practices. Now, this concept of accepted market practices has been borrowed also from what we call the MAD regulation rules. That's the Market Abuse Directive, which applies to the financial sector. And the MAD directive is currently also, of course, being revised and will be replaced by the Market Abuse Regulation. And in fact, it's interesting to note that in that sector, they've kind of given up on trying to delineate accepted market practices. It's proven to be very difficult to come up with an acceptable set of guidance. But the second edition of ACER's guidelines, which I'm sure we'll hear more about from representatives from ACER who are here today, there we see a renewed attempt to make clear what they accept as accepted market practices, and where they make a distinction, which they might want to elaborate on, between accepted market activities and accepted market practices. And in fact, they say, well, certain activities cannot be deemed as market practices, and therefore we must always look at the level of market practices. So this is another of these very vague areas under REMIT where we're not really sure yet what will be within this accepted market practice safe harbor. Now, turning to what's going on with financial regulation, it's taken a long time to revise the Market Abuse Directive and turn it into a new measure, the Market Abuse Regulation. And there has been a sort of compromise position between the Parliament and the Council in December 2012. And the compromise definition I've put here is that market abuse is a concept that encompasses a lawful behavior in the financial markets, because this regulation will apply to financial markets, but we follow it carefully for energy markets. And for the purposes of this regulation, it should be understood to consist of insider dealing or the misuse of insider dealing and market manipulation. So such behavior prevents full and proper market transparency, which is a prerequisite for trading for all actors in integrated financial markets. So we know what the purpose is, why we need it, but we don't yet really know how to define it. We don't. There's often, I think, the reaction you hear is, well, you know it when you see it. That's how you identify market manipulation, which is perhaps not a very encouraging reaction, because you will not know until perhaps you've committed the particular crime. And I say crime intentionally because this type of activity will be penalized with criminal sanctions once the final implementing powers are rolled out in June 2013 of this year. I have included a few examples of the types of market manipulation that are condemned in the financial market, and you can look at those at your leisure on the slides. I think there are some rather amusing names: spoofing and layering, pump and dump. What we see in practice, just rounding up, is that REMIT is definitely going to have a much wider reach than competition law. Much wider reach than competition law. You can look again at the examples that I gave you. Spanish market, another example, Scottish generators were also accused of withholding capacity and then bidding into the balancing market and actually earning very substantial sums of money, but it was impossible for the UK regulator to prove that there was dominance and collusion on that particular day. And in order to stop them being left with empty hands in the future, there have already been new licensing conditions, transparency requirements introduced into electricity generating licenses in the UK, already anticipating the types of powers that regulators will have and the duties that generators will be required to follow under REMIT. So, just a final comparison, and then I stop, as which kinds of instruments should be available to regulators and competition authorities in the future. Well, physical withholding of capacity, that can be covered by REMIT as a form of market manipulation, and we've seen a lot of instances in the last years where this is something that competition authorities have tried to deal with. So which instruments are likely to be used? Well, I think one easy conclusion is that if dominance is going to be difficult to establish, then it would be better to go for REMIT and use the powers under REMIT. What about collusive behavior? Can we attack that as a cartel? Or should we look at that as also a form of market manipulation? And here there is a classic case of market manipulation in the region of Naples, which was condemned by the Italian Competition Authority, where what was interesting in that case was that the parties were actually able to collude because the market had become so transparent. So they knew exactly what was happening on the day before they decided to withdraw capacity from the market, and therefore they could optimize the prices that they were going to bid for in the balancing market. So this was an example of where perhaps too much transparency led to collusion. Nevertheless, collusion can be attacked and condemned under competition law, and that's what was done by the Italian Competition Authority in that case. When we look at what do we do if we have established either market manipulation or abuse of dominance, there are also differences. Competition law has increasingly demonstrated itself to be very flexible because often competition authorities will reach these settlements with companies, and the companies will modify their behavior. So this settlement process is a very efficient one because it avoids going to court, it avoids competition authorities and regulators having to write long, complex decisions, and for the company in turn, there's never actually any proof of what it's done. So it can avoid perhaps sanctions in terms of damages that would be claimed from consumers or its competitors, because there's no proof that it has actually infringed competition law. So a settlement is a sort of win-win situation for both regulators and companies. Under REMIT, however, we don't have that option. We only have the option of imposing sanctions. And these are likely to be criminal sanctions that will be imposed on persons rather than on companies. So that means, from a legal point of view, there will also then have to be a much higher standard of proof. You can't impose a criminal sanction on a person unless you have proof beyond reasonable doubt. So probably in the short term, we'll expect to see REMIT being a very important way of tackling particular issues in electricity markets, and maybe to a certain extent gas markets, but particularly electricity markets. And that has been these cases where there has been withholding of capacity and where it has been very difficult for the regulators or the authorities to establish dominance. So if they don't have to do that, and they can go straight to the market manipulation tactics and prove that, albeit to a high standard of proof, then they're probably better equipped than they are with their old competition law provisions. So I hope that that gives you an idea of the different ways that lawyers look at market abuse from a competition law point of view, or from the point of view of this new set of rules under REMIT. So I'm open to questions. Thank you.